One of the hardest parts of the Commodity Exchange Act to understand is how retail foreign currency is traded. So we'll go over that today. Part of the reason it's so hard to understand is that Congress did such a terrible job in drafting this section. And there's a lot of parts of the Commodity Exchange Act that are terribly drafted, and this is probably the worst. But let's get into it. So this is the original section that granted the CFTC jurisdiction over retail Forex. It's 2B. So section 2C2B was the section that originally granted jurisdiction to the CFTC to trade off-exchange retail foreign currency. So obviously, foreign currency that's traded on an exchange is covered by the sections of the Act dealing with futures and options and exchange trading, etc. But this deals with off-exchange foreign currency trading. So retail customers were not supposed to be involved in foreign currency trading, but through a quirk of history and some bad legal precedent in the courts, it sort of opened the door to this, and this section was meant to address that, and it gives jurisdiction over off-exchange trading in foreign currency that's a commodity for future delivery, i.e. a future or an option. Now, futures by statute are supposed to be traded on an exchange, and that doesn't mean that trading futures off exchange makes it not a future, because there is a section of the Act that requires all futures to be traded on an exchange. And there's a canon of statutory interpretation where if there's two sections of the Act and you read one in a way that the other one is null or doesn't make any sense, then you can't read it that way. So futures are what they are, and they're required to be traded on an exchange, except when it comes to foreign currency. And traditionally in the Second Circuit and Ninth Circuit, they had this multi-part test where they discussed what a commodity for future delivery is, and it involves something that is fungible, a commodity. There's a reference price, there's leverage, and there's settlement by offset, yada yada. And that was the case, and when the CFTC would bring fraud actions, they'd have to use that multi-part test and prove that the contracts that these people were entering into with retail customers were a futures contract using that multi-part test. But then there were a couple of cases that went against them. One was called Zellner, one was called Erskine, one was in the Seventh Circuit, and the other, I believe, was the Sixth Circuit. And those cases said that you can't look beyond the four corners of the contract. So even though these had the elements of a futures contract, and in 100% of the cases, delivery did not occur, if you look within the four corners of the contract, delivery could be required. And so they said that that would be forward contracts, not futures. And if you want to know what a forward contract is, I have a video on that. You can check that out. But now you had this split of authority, the Second Circuit and the Ninth Circuit saying one thing, and the Seventh Circuit and the Sixth Circuit saying something else. And that caused a problem, and also gave fraudsters a roadmap for how to operate, because if they said that this contract in Zellner and this contract in Erskine are something that the CFTC does not have jurisdiction over at all, then if you wanted to defraud people, you can just use the exact same contract and get new customers. So Congress stepped in and they added a new section. So 2C2B, they added 2C2C, which looks exactly like 2C2B, except for two things. One, it doesn't mention a contract for future delivery. It talks about any contract with a retail customer where the FX being sold is leveraged or margined or financed by the offeror, and delivery doesn't occur within 2 days, actual delivery. And actual delivery is important because there is a canon of statutory interpretation that every word in a statute has meaning. There's no such thing as extra words. So unlike when you buy something from IKEA and they give you extra nuts and bolts, there's no extra words in a statute. Every word has a meaning. So actual delivery doesn't mean constructive delivery, doesn't mean symbolic delivery, partial delivery, constructive delivery, nothing. Actual delivery means you get it in your hands. So these contracts that were purported to be forward contracts that were 2-day delivery, and then every second day they would just roll it over to a new contract, delivery never occurred. So this was meant to cover those contracts that were the topic of the Zellner and Erskine cases. So actual delivery, if I entered into a contract to buy euros, 2 days later, I would get euros in my bank account, which is how institutional Forex trading works. So that's one thing. It broadened it so that it would cover not only futures and options, but everything that is leveraged or margined or financed by the offeror. And it has this little carve out also, which creates an enforceable obligation to deliver between a seller and a buyer that have the ability to accept delivery in connection with their own business. So what does that mean? Well, let's say I'm an importer exporter and I enter into a contract with a bank and I have the ability to make and take delivery of the foreign currency, and so do they, then even though we have less than $10 million, because uh, that would make me an ECP, an eligible contract participant. If I have less than $10 million, I'm considered retail, but I have the ability to make and take delivery. So even if actual delivery didn't occur within 2 days, I would still be okay. And you might say, well, doesn't everyone have the ability to make and take delivery of money? Yes and no. I can take US dollars in my bank account, but if you tried to send me yen or euros or something, I wouldn't be able to do that. I'd need a foreign bank account, and an exporter, importer would likely have that. So that's what that section is intended to cover. And the really interesting part of this is if you scroll further down, and with regard to 2C2C, this so-called Zellner fix, it says that section 6B and 6B, well, it says that sections 6 parens B and 6B shall apply to any agreement, contract, or transaction described in section 1 of this paragraph, which again is Forex futures and options and leverage or margin Forex. And it'll apply as if the agreement were a contract for sale of a commodity for future delivery. So it applies as if they were futures. So what are 6B and 6B? So 6 parens B is foreign transactions, and 6 little b is fraud. So the CFTC can go after people for fraud without having to prove that these are futures. And again, traditionally the CFTC has only had jurisdiction over futures prior to Dodd-Frank. But when it comes to retail Forex, because of this Zellner case, which limited their jurisdiction, this new section was added where it gave them jurisdiction over retail Forex that's leveraged or margined or financed by the offeror. So a lot of these so-called rolling spot transactions now you didn't have to prove they were futures as long as it was leveraged or margined or financed by the offeror and delivery did not occur within 2 days, then you can go after them for fraud as if it was a futures contract. So you didn't have to prove it was a futures contract. So now, if you've got 2 sections of the Commodity Exchange Act and you're in the enforcement division of the CFTC, and you can bring one under 2C2B, which relates to futures, and you can bring one under 2C2C, which covers everything else. And with 2C2B, you have to go through this multi-part test and prove to the judge, who may have never heard of a futures contract, that this is a futures contract, and go through the elements. It's fungible, it's a commodity, it's got leverage, futurity, it's a reference price, settlement by offset, and you'd have to prove all that and convince him. Or you can just go with 2C2C and say, if it's fraud, we can go after them because delivery didn't occur within 2 days. And this is so much easier to prove than all the cases after this section was enacted were sort of brought under 2C2C instead of 2C2B because it was much easier to prove. And that became the way that they litigated all their cases. Now, I mentioned before how poorly drafted this section is, and I'll give you just one example. So if you look at these sections, AA, BB, CC, DD, FF, it ends at FF. And here it refers to section GG, which doesn't exist. So in an earlier draft of this statute, there was something else here, which meant that this was GG, but they deleted something, and now this became FF instead of GG, but they didn't change the other sections. So this is supposed to refer to CC and GG, so FCMs and the newly created retail foreign exchange dealer, but because they deleted a section, this refers to FCMs, CC, and GG, which is nothing. So technically they call that a Scrivener's error. They actually write law review articles about it. And in the swaps rulemaking, they reference the Scrivener's error. And if something is clearly wrong, it's a clerical mistake, a judge can interpret that as a Scrivener's error and write into something into the statute that doesn't exist. And the CFTC sort of did that in their release. And normally that would get some weight in the court, but there was a case that was recently overturned. So normally when dealing with their own statute and it's very specialized, administrative agencies would get what's called Chevron deference. So if there's more than one way to read a statute because it's ambiguous, a agency that specializes in that statute, their opinion on how that meaning should be interpreted would carry weight with the courts, and that was called Chevron deference, but that was overturned recently by the Supreme Court. So now the judge gets to decide, and no one's interpretation gets more weight than anyone else. So I don't know if the spelling out of that Scrivener's error in the CFTC's release would carry weight, but I mean, it would put people on notice, because if you charge somebody with a violation, they have to know that they have broken the law. And if sections of the act don't line up and you were looking at it, how would you know that that referred to you or to your situation? But if the CFTC has put out information making you aware of this, then arguably you're on notice. So that's the legislative part of the Commodity Exchange Act dealing with retail foreign currency. When you deal with retail foreign currency, most people refer to it as Forex. And when you deal with institutional foreign currency, most people refer to it as FX. And the CFTC, post Dodd-Frank, when they were given authority beyond just anti-fraud to regulate retail foreign currency, ended up drafting a series of regulations to create this new category of registrant called retail foreign exchange dealer, and have rules regarding retail Forex. And I drafted those rules. And this video isn't going to go into those rules. We're just covering the statute, but I may cover the rules later. If you have any questions on this or any other videos that I posted, just leave them below.
Here's my favorite part, the disclaimer. I'm a lawyer, but I'm not your lawyer. Anything you see on here is for educational and informational purposes only. If you have a specific question about your specific circumstances, seek your own legal counsel for those questions. Nothing here creates an attorney-client relationship between me and you. I am not your lawyer. Okay, got it? Have a great day, everyone.